An Ohio last will and testament ensures an individual's property is well managed after death. The document is rather simple to make and, best of all, doesn't necessarily involve seeking legal advice from an expensive attorney. In this video, we'll look at the importance of wills and what happens when one isn't made, what's included in wills, legal requirements in Ohio, and how and where to create an official will. First, let's discuss wills and their importance. A last will and testament, simply known as a will, allows an individual to set instructions on how their property is to be distributed between beneficiaries upon death. Beneficiaries are typically spouses, children, and other relatives. However, they can be any person or entity. It's recommended for all adults to have a will, especially those who are elderly or facing life-threatening conditions. Now, what occurs if no will is left? A person who passes away without a will loses full control of who inherits their property. Instead, Ohio law determines how the deceased assets are dispersed. Typically, the deceased spouse, children, or blood relatives inherit the property by default in these cases. Leaving one's property in the hands of the state may cause loved ones to dispute the decisions made by the courts when distributing the estate, possibly leading to contested court trials. Luckily, all instructions can be documented by making a clear will, and usually without an expensive attorney required. A person of sound mind can draft a will in Ohio with the following information on the document: their full name and residing address, the information of their personal representative, also known as the executor, who will distribute the assets accordingly, the names of all beneficiaries, and a thorough list of the property each shall receive, any additional terms and conditions, and the signatures of the testator and 2 witness signatures. And finally, let's review legal requirements in Ohio. Last will and testaments in Ohio must be signed by the person to whom the will belongs, known as the testator, in the presence of 2 or more trusted and competent witnesses. Though optional, it is recommended that both witnesses be disinterested parties. Disinterested parties are individuals who do not stand to personally benefit from the will or receive a share of the testator's estate. Once all parties have signed, the document will be legally binding. Several copies can be made and given to trusted individuals for safekeeping. Were eForms the biggest database of legal documents? We have created state-specific last will and testament templates specifically designed for Ohio that are quick and easy to fill out. Our software generates an official document after you select your desired will instructions and name all of your beneficiaries. Click on the link below to begin creating your will. And don't forget to like and subscribe for more daily videos.